approved by the school committee, but the penalties in them are brought to the student councils for discussion and input and suggestions and buy-in and support and discussion. So I would view changing in penalties the same. And the other interesting, not unique, but pretty standard, where the chemical health policy for athletes is the 62.1 of the MIAA. In your handbook, you also expand the same analogy of that to student activities. And then you also, in the handbook, you actually physically incorporate 62.1 into the handbook. Here it was the 49 and 50. So you've got the penalties written in your handbook. So as general guidelines, I think this would also be a question of the appropriateness of bringing any change in the penalty for discussion to the student council, and suggest that you might consider that. On the authority level, and this is meant to be kind of an overall legal assessment. I'm not trying to cross over into your area of policy making, but in the general legal assessment area, extending something beyond the calendar year, if viewed for whether that's valid or not, it probably more likely than not would be found to be a broadening of your authority. There's no state law precedent on that. No appellate court has ever decided that. But you look towards what are the education laws. And all of the education laws with the regulations that say how school committees and school administrations are supposed to carry out their obligations are defined in terms of the school year or the academic year. Most recent point, the bullying law. And that obviously is those regulations are going to be very specific, and that's in all of the time periods in which the obligations of the school committee and the principals and the faculty are defined in terms of the school year and the academic year, or the length of the activities. So looking at the legislative intent, there's nothing that would indicate that the intent was to have school committees make policies for the non-academic, over students over the non-academic year. So if challenged, the challenge would be to whether it's valid on its face by extending the scope that broadly. Not whether, and then if it's not valid, you can't enforce it. So I can't say with any certainty, because there's no example as far as we know where that has been challenged, and I'm not familiar with any policies currently in place by any school committees in Massachusetts in which they have extended it to the full year. School committees file their policies with the DESE. They're not there for review. They're just on notice on file of them. And then also the other standard issue is whether it would be valid to be enforced against somebody who's in the presence of. That would also be a likely constitutional challenge. Students do not have a constitutional right to participate in extracurricular activities or athletics. It's a privilege. But once you do set up those programs and have them, and students participate in them, to exclude one person from them and not another has to pass the test of basic what we call procedural due process, where the two basic concepts of that are fairness and reasonableness. So that's what it would be judged under if challenged. Basically, it should be all of the weight and discretion should be given to the school authorities during that, but it is unprecedented in finding a person, imposing a penalty on a person without being able to establish their knowledge, maybe that they were violating the policy, or their intent, because those would be the two key things. Did the person know they were in the presence of somebody, and did they intend to be in the presence? So if they had no knowledge or intent to violate the rule, is that reasonable and is that fair? And I think that would likely not meet a constitutional challenge if it was brought to that. On the issue of penalty, let's take the treatment versus the educational program. a school committee cannot mandate medical treatment or therapy unless it's per court order or an IEP. That's why, that's why it's voluntary under Rule 62.1, and it's a mitigating factor. Somebody could voluntarily participate in a program and have it certified by the principal, and that reduces the amount of their penalty. But they're not required to, not required. They can take the whole penalty if they want. And that's that's just once again out of the issue of, can you force somebody to participate in medical treatment or therapy. Now, that's different from an educational program. An educational or instructional program, you certainly can mandate. So if you addressed, and whether you want something mandated or a voluntary option after a first violation versus a second or third is certainly part of the decision, and there's no restriction on that. A couple of reasons on mandating treatment also. If you broadened your sort of authority on that, you'd potentially be exposed under the State Tort Act. If there was a problem with that program, or the student was exposed to some unsafe condition or a lack of supervision, let's say, and as school officials, you're governed also by federal law under Section 1983. So you could increase your risk and take on an obligation beyond, sort of beyond maybe the intended risk. But more specifically, if you don't have control over a program, if you don't know the content of the program, you don't know who's running it, you don't know what provisions they have for the safety of students there, but yet you mandate it, then you are assuming the responsibility that it's run by qualified people, they're running it in a safe manner, and that a student's not going to be exposed to some sort of unnecessary risk or harm just by participating by some, let's say, some unique technique that a therapist wants to control. So the sort of model for that is the community programs through the district attorney's office and the MIA and community groups and service groups. They have a lot of recommended programs that are established programs that are licensed by the state, and you could provide resources of those and recommend those, but it should be the family's choice and the student's choice. For an educational program, if you required it, you'd also be responsible for paying for it. You could have something that was instructional or educational in nature and require a student to do it during their free period or even within a reasonable period of time after school. It's unlikely that you could require that to be done on a Saturday or an evening. That issue is still out there, for the detentions and the avoid suspension by doing something else. That's never really been ruled on. It's been challenged. So as a discipline, if you mandate it, you just probably want to look at when it's offered and keep it within a reasonable period of time related to the school hours. And you could certainly mandate a program like that, and you might, and that might be related to doing an independent project on the computer, and having a certain time to do that, working with a health or science teacher on the issue. You could mandate going to a school counselor, but once again, not outside counseling or therapy. So and you do have in the handbook for the extracurricular students, for the third offense, it does mandate. It is a mandate, it's not an option, like it is in the 62.1 policy. So I would recommend that you consider, it does say educational, but it also says treatment, and just be clear if you're mandating that's an educational or instructional based program or an in-school counseling or a school control program, and not an out-of-school mandated program. So you might want to take a look at that.
So summarize, I think, try to summarize what you've said. Basically, if we did some of these things in terms of either making penalties harsher, covering the whole school year, or the whole year rather than just the school year, and a few other things, we'd kind of be putting ourselves out there on a limb all alone in terms of if someone wanted to challenge us, file a suit, whatever, we wouldn't have a lot of backing from anybody else because we were the only ones who have put these penalties out as far as we have, or have decided to cover the school year. For example, the MIAA probably isn't going to back us if someone filed a lawsuit because we penalize somebody for something they did over the summer, because the MIAA policy doesn't cover the summer. I'm just wondering if that,
I mean, I think that's accurate. They do say it's a minimal penalty, so if you increase the penalty, they should not, that should not be outside the recommendation. But increasing the penalty is different from increasing the scope of who's covered by it. By the, because the 62.1 expressly excludes guilt by association. So the MIA has gone on record as saying, that's not what our policy covers. So you would not get support from the MIA in that. And they went from the sport of the, the calendar of the season to the full school year. They made that extension, but they have, like any organization, they have procedures to change their rules. And you have delegates from administration, from the athletic department, from your principals that are delegates to their board of control. And so they're going, their mission is to have some consistency between the communities for fairness of play. So I would not anticipate, if you extended to the school year or to guilt by association, that they would have any interest in supporting that. And that's a balancing too, because to be consistent with the MIAA, if there is a challenge, they immediately step in and take the lead on that. They bear the cost of that. They have attorneys on retention that handle those matters all the time. So the school is named as a party to it, but their role is is just really providing the facts. The MIA will support before the courts the enforcement of their rule and the validity of their rules, and have done so repeatedly. So yes, you would be a test. You would be out there sort of as a test case. And I had sort of raised just as a question, sometimes it's better to go along if you want to make a really significant change. It's usually easier to go along in a group than to really be out there on your own with that challenge. The extension to the full year for the motor vehicle violation, that's clearly within your authority to extend and have a harsher penalty. But once again, that is a much more significant penalty than the MIA, so I think I can't speak for them whether they're enforce that, but you'd be out of sync with the 62.1. So you might want to balance the benefits you get from being consistent with 62.1 versus separating yourself or the reasons why you feel you need to distinguish yourself from Rule 62.1. And what is your underlying reason for having a different rule, and can you address some of your concerns and stay in sync with that rule to the extent that you would want to with that.
comments, questions?
Sure. As it turned out, I was the principal author for this policy change, and the initial effort was to try to bring consistency within coaches, but the challenge then was how can you fix this thing so that it will be more effective. Unfortunately, the person that was the principal author, me, is a hanging judge. I'm a strict disciplinarian, and I tend to believe that you increase the penalties to the point where you don't get violations anymore, and whatever that takes. I very much appreciate the inputs that we've had from you and from Mr. Bernard, as well as the other committee members. What we've done, I think, is first off, I think what we were able to do is we were able to get Mr. Bernard to increase the penalties overall, which affects more than students who are involved in activities and in sports. It involves the entire student body and puts not just sports or activities at risk, but puts their academic standing at risk, which is a very much stronger approach than we could get in this policy, because we're dealing with the academics, and that's going to attract their attention. And I think